Good evening and welcome to the first in our series of Financial Remedy webinars. I'm Sian Smith and I'm delighted to be joined by your experts this evening, Desmond Kilcoyne and Jeremy Hall. Desmond is going to take us through Stack and Dowden and developments in that area of the TOLATA update, and then Jeremy is going to take over and deal with some of the other issues, including occupation rent and rectification. So I don't need to say any more. I'll just hand over to Desmond to kick us off. Thank you very much.
Thank you very much, Sian. I'm sorry that we haven't got a snappier title for this evening's webinar. One of my daughters did suggest you say TOLATA, I say TOLATA, which I thought was funny, but I don't think it means anything, so I decided not to suggest that. What we're going to do today in my section of the talk is we're just going to cover basic principles in Stack and Dowden and look at about 6 recent decisions. And Jeremy is also then going to deal with other aspects of co-ownership, particularly occupation rent, and 1 or 2 other interesting cases, again, that there have been in the last couple of years. So if we turn to the second slide, I've rather, I hope not too presumptively, put a heading there, the common intention constructive trust. That is what we're going to talk about. And I've put the words there at the very top, the foundation case. And it's a case, the case of Lloyds Bank and Rossett, it's an old House of Lords case. And I do think that it is a very important and fundamental case, which is still resonating and very valuable today. You'll all recall there are 2 very straightforward principles in Lloyds Bank and Rossett. The first principle is on the next page, namely that a constructive trust can arise when in 1 of 2 situations, and the first situation where it can arise is where there is an agreement, an arrangement or an understanding between 2 or more people that there will be property rights in a property that is shared beneficially. That agreement, arrangement or understanding must arise out of express discussions, and if you can establish that, then all a party who's claiming to enforce this arrangement needs to do is show that they acted to their detriment in reliance on the agreement. That's the first basic principle. The second basic principle, which is on the next page, is a backup principle. It's very like the old resulting trust. I know we're not supposed to talk about resulting trusts these days, but it's very like the old resulting trust. And it says a common intention resulting trust can arise out of simply the conduct of the parties. And that, where that occurs, what the court will be doing effectively saying that the conduct of the parties is such that it is possible to infer a common intention. And of course, it's very well known that the usual scenario where this second type of situation will trigger a common intention constructive trust is where there are direct contributions to the purchase price, payment of conveyancing fees, a deposit, payment of the balance, or taking liability under the mortgage at the time of the purchase. Those are 2 foundation stone cases that underlie the subject. But Lloyds Bank and Rossett really gets dramatically less mention these days, because on the next page, we'll see that 2 Supreme Court cases, the case of Stack and Dowden and Jones and Kilcoyne, have really rather eclipsed Lloyds Bank and Rossett. Now, what I'm going to do in terms of a theme today is I'm just going to allude to 1 or 2 issues, interesting issues, I think. They're also practical matters. 1 or 2 issues that seem to run through reference to Stack and Dowden and Jones and Kilcoyne. It's fair to say that in Stack and Dowden and Jones and Kilcoyne, the Supreme Court really had a very good rummage around the whole subject. They discussed lots, not only the particular principle that they were applying in the cases before them, but they also discussed side or peripheral areas. Both of these cases, for example, were joint ownership cases, but there was significant discussion about how one deals with sole owner cases when one's trying to establish a common intention constructive trust. And there's lots of discussion about that in these two cases. The principles actually applied are quite narrow, though, in Stack and Dowden and Jones and Kilcoyne. So if we go to the Stack and Dowden, the actual case, the principle that was applied, what the court did, and I don't know, as practitioners, the way that you viewed the subject before Stack and Dowden came along, that it certainly was a shock to me a little bit. What Stack and Dowden said was, where in cases where two or more persons buy a home together, cohabiting, not quasi-matrimonial home, but moving in together, and they're setting up family life, a domestic situation. In that type of case, if they buy a property together and both names go on the legal title, the presumption is that they will both share beneficially in equity as joint tenants. In other words, equity will reflect the law. And as joint tenants, that's effectively saying that they will both get a 50-50 share. Now, if and when the property comes to be sold or there's a dispute and the like, what was particularly significant as a social, political, or indeed as a matter of law, what was particularly significant was the emphasis that this is important and this reflects the reality, this should reflect the reality, and the supplementary point that if you want to try and shift that presumption or rebut that presumption, it's going to be quite difficult. So when co-owners go into a transaction and they buy a property together, both should realise that it's going to be difficult to argue at some subsequent point in time that they actually own it in some different way in equity. And this is I put down on this particular page, I put down the fact that wording used by Baroness Hale and the court say it's really rather exceptional. It'd be exceptional cases where you're able to rebut it, the presumption. And this is one of the things I want to talk about or refer to today, because I think it is one of the most interesting points that's come up in a recent authority. Is this strong presumption that the co-owners will own as joint tenants, is that a common intention constructive trust? That's the first question. The second question is, if you challenge the stack presumption, if you challenge it and you succeed in rebutting the presumption so that the court will be persuaded to apply something else, not a 50-50 balance in terms of the shares in equity. If you persuade the court to change the balance and move away from joint tenancy equity, is that a common intention constructive trust? Now, interestingly, this was a question that I was recently asked by another of my daughters, and actually, she's studying the law, and it gave me some considerable cause for thought and pause for thought, because of course, to call the basic presumption, the result of the basic presumption, or indeed to call a common intention constructive trust that arises where basic presumption has been rebutted, to call those a common intention, either of those situations, a common intention of constructive trust, is really rather a little bit at odds with the principle as we formerly understood it, in Lloyds Bank and Rossett. Why? Because there's no mention in that discussion of detrimental reliance, certainly not an express mention. So I want to come back to that point. The significance of this is that if all you have to do to rebut the stack presumption is to show at the very start when the property is bought, or at some point in time later on, that there's a different common intention, that means really the game is afoot. It's possible to try and challenge the basic joint tenancy position simply by arguing in all the circumstances that the parties had some different change, and it's quite clear they had some different change of common intention. You don't need to worry about whether there was any related detrimental loss or expenditure incurred or financial liability incurred and the like. It will be remembered that Lord Hoffman, and in the discussion before the judgment was given, and Baroness Hale, in her judgment, referred to what's called an ambulatory trust. The idea that this trust, this Stack and Dowden trust, is actually capable of common intention in constructive trust, is actually capable of changing over time. It walks along. And Baroness Hale suggested or implied that if parties change their intentions, and they both do have a different common intention later on, well, then the nature of the trust changes. And again, the question is, well, do you need detrimental reliance for that, or is it just simply a change of intention? And I'll come back to that. We go to the next slide. There are two questions hanging over the cases that we're going to discuss quite quickly today. We can't go into great detail. There are two questions. The first question is, and this is on the next page, this page, thank you. The question is, to what extent does can the Stack presumption be rebutted simply by establishing a different common intention? Or do you actually need, in rebutting it, do you also need to establish detrimental reliance? That's one question I'm going to look at. We have no less than 3 cases to look at on that. The second question I'm going to ask, it's a slightly more peripheral point. As part of the periphery of Stack and Dowden suggested that really common intention in constructive trust is really for the domestic or the informal type of situation. And what they tried to do in Stack and Dowden, the Lords, is tried to indicate that really common intention in constructive trust should not be involved in the commercial context. Really, commercial context should be all about money, finance, and resulting trust, just pure financial analysis. I'll come back to that as well. Very quickly on the next page, I'll just refer to Jones and Kernot. I'm not going to dwell on that for long. You'll remember the Jones and Kernot principle, which is that there are effectively 2 stages. You can call it 2 or you can call it 3 stages, but there are fundamentally 2 stages involved when you're considering common intention and constructive trust. The first stage is this establishing whether the basic principle of common intention is made out. In other words, is there actually a common intention that both the parties are going to have a beneficial share in the property? That's the first stage, establishing the trust. You get an interest of some sort, of some size. We don't know what it is. It's just an establishment of the interest. The second stage is actually quantifying what the size of that interest should be. Jones and Kernot really, in terms of its importance, is really focused on that second question. It says that where you've really got no evidence at all, once you've established that a trust should exist, and it does exist, you've got really no evidence about it at all, evidence of agreement and the like, you can impute an intention to the parties that they were going to, they agreed or had a common intention that they would both take a fair beneficial share in the asset. It's about that word impute or imputation. That's the significance of Jones. But I don't think there have been any recent cases that are really interesting about that. Nothing that we're going to discuss today. So we can, to some extent, forget about Jones today. So if we go to the next page, we're going to look at 6 cases. We'll take them quite quickly. Those I've given you the citations there if you want to go and have a look at those later on. And we'll start with the first case of Amin versus Amin. And this is we're going to look at it in terms of Stack and Dowden or co-ownership share side of things. I'll just run through, as with all of these, quite quickly the basic facts and give an overview or give you an idea of why I think that it's either interesting, just as an example case, which you may need to know about, or if there's something deeper there or an expression of principle that might interest you when you're dealing with your particular cases. It's a sole proprietor case, man and woman. I'm going to use M&W as man and woman, who are not married under UK law. And they bought a property in their joint names in 1995, but they didn't move in. Now that should signal that this might not be a Stack case, because generally speaking, Stack was confined to that notion of people who move into the same property together. On the other hand, you could say it's very close to Stack. Unusually, this particular property was then sold to the woman's cousin in 1999 to raise finance. So we can see that and the backdrop to this was that the family dealt in properties. They had more properties than just this particular property, and the properties moved around within the family. But what happened here is that 6 years later, in 2005, the property was sold by the cousin back to the man and the woman, and they moved in to live there. And so that is a classic stab situation. They moved in 2007. So I'm not going to go into the background, the complicated sort of financial backgrounds, but the judge had to analyse over 20 years worth of interactions and correspondence and the relationship between the parties for over a very long period of time. We've all seen those. But the judge ended up concluding that the woman had made no contribution to the purchase, and that the man had paid all the mortgage payments and worked on the property. And in those circumstances, he found that there was a common intention and constructive trust in favour of the man and also the couple's two sons. And what happened in this case was that decision was appealed. This is a decision of Judge Saunders in the County Court. And what's interesting, again, it's one of the interesting features of this, is that the judge wasn't able to make findings about very early years. And one point particularly that might occur to you is that when the property was purchased right at the start in 1995, in joint names, there seems to have been a joint mortgage. There's reference to a joint mortgage in the appeal decision. And normally that it triggers a liability on both parties to pay for the mortgage. And normally that provides a strong basis for arguing that you've contributed to the purchase price of the purchase if you accept a liability under a mortgage. Not clear why, on the facts of this case, the judge didn't look at that point and identify that could be a possible contribution by the woman. And this is referred to in just a couple of lines in the appeal case, and that's simply not mentioned. But anyway, the decision was that she had not contributed, and on appeal, that decision was not challenged. So the starting point was that the judge was right, that she had not made a contribution. And there was also criticism of the decision that he had not focused on making a finding about common intention. And one can see almost that if you're dealing with 20 years worth of dealings, it's actually probably quite difficult to marshal a commentary in a judgment saying at this point in time, I think the common intention was this, or they didn't have any common intention and they were at odds with each other. One can see that it would be quite difficult in practical terms, possibly to marshal all that and keep that rolling along before the judge reached his final decision. And to some extent, that's exactly what the appeal court found. They said the judge had certainly got the test right. He knew what he was doing. And in the circumstances, they said he had actually made a proper finding regarding the ownership. One of the interesting things, and I put this at the quote at the bottom of this page, one of the interesting things is that in fact both parties were saying they had 100% ownership. So the appeal court thought it was very much an all or nothing case. And what is interesting is that the judge actually reached a finding that accorded with neither side's case, that it was slightly different because, as I've said, he decided that there was a common intention that the sons would have a share. And this was quite an interesting finding if we turn over the page. It's quite an interesting finding because there was really very little basis put forward for that. It was very much something he decided of his own volition. I suppose it just reflects the fact that judges, as finders of fact in court, can actually reach decisions, and it's not absolutely unheard of. Where in fact they don't agree with either side, that they find that something else is in fact the right answer. Finally, the final quote I've put on this is from the judgment, where the judge on the appeal court says, "I accept that detrimental reliance is a requirement for a common intention and constructive trust." That's a very clear, ringing endorsement of the principle that detriment for any common intention and constructive trust, there's no sense of an exception, although this isn't a joint names case. in any common intention constructive trust, detrimental reliance has to be found. So at the end of the day, on the basis of no contribution, this was a case that went entirely against the woman, and you might say that might be slightly surprising in the light of the history with a joint mortgage and initially a joint purchase, but this was really the result. Was really a result of the evidential weight, obviously, against the woman in that case, and that she wasn't believed substantially in her evidence that she gave, and as a result, she lost. So let's move on to the next case, which is O'Neill and Holland. It's another sole proprietor case. I won't dwell too much on this case. It's another sole proprietor case, a man and a woman who weren't married. But in this case, the purchase of the property did not occur by them in their own names initially. It was the woman's father purchased the property for them to live in, and they lived there. So they lived there with him as the owner of the property for about 9 years. And it was only 9 years later that the property was then transferred to the man in his sole name for no consideration. So the woman's father has bought the property with his money and eventually transferred it just to the man for no consideration. What does that feel like in terms of beneficial ownership, or where the rights of this may lay? The relationship broke down 3 years later, and the woman moved out. And the father had sadly died, so he wasn't involved in this. The trial judge said that the reason why that the property hadn't been transferred into the sole name, or it had been transferred into the sole name of the man, was because although there was an original arrangement that the woman would be on the title, the man had falsely misled her by saying that a mortgage which they were arranging couldn't be obtained if she was on the title. So she agreed, and he went on the title alone. The father died, and then she was left living in the property with him under him as the sole owner. And of course, when their relationship broke up, his name was on the title. The judge found that there was a common intention that the property was to be owned by both of them, and also found that it was unconscionable to deny that common intention, and that therefore the woman would have a 50% beneficial share, which makes sense. And on appeal, the appeal court, and sorry, I do apologise. There was the first appeal. There was an appeal where an appeal judge allowed the man's appeal. The man had said there was no finding that the woman had acted to her detriment in reliance on any common intention. So the initial judge said there was a common intention, and it was unconscionable for the man to resign from that common intention. So the first appeal was that in order for the woman to make good that argument, in order to establish a common intention trust, the woman also had to show that she relied detrimentally on that common intention or that agreement. And in fact, on the first level of the appeal, the judge overturned the judge, so the man succeeded. So there was a second, and this is obviously an unusual appeal, woman appeals by way of second appeal, and the senior appeal court upheld the initial judge. And the way they did so was effectively to say this. They said, first of all, no, the first appeal judge was right. The judge on the first appeal had been right to say that detrimental reliance was necessary. So as a matter of principle, you do need detrimental reliance. Therefore, the trial judge was wrong in not focusing on that. But secondly, they said that on the facts of the case, in fact, the detrimental reliance had been established, because in this particular case, the woman had done acts which were referable to their joint lives. And that was the test that the second appeal court used. There was detriment relating to their joint lives. And the reason why there was detriment was because the woman relied on the fact that the man had said that the mortgage could only be in his name. And and that was detriment because she then was not in a controlling position as a co-owner of the property. If he had not misled her, then she would have been on legal title, and that sufficed for the purposes of detriment. And this, if anybody remembers the name of Granton Edwards, is not an uncommon. It's not a surprising result, and it's already a similar sort of case was decided many years ago in the case of Granton Edwards. So, if we go 2 pages over to the case of Oman and Collins, I'm slightly skipping over some of the detail. We would emphasise that our printed notes are available if you'd like to contact the clerks or Sophie, who will have sent out the invites after today. Then you can get some of these notes. We've tried to provide synopsis and some of the key points of principle. But if I go over the page again to the next case, which is Oman and Collins, and I'm going to take this quite quickly. Oman and Collins. It's both a sole and joint proprietor case. Now, why do I say that? It was a man and woman. Again, they were not married, but they had quite they worked extensively in business and in the property world with each other. They had 1 property solely in the woman's name, 7 properties in their joint names, and 11 properties in the name solely of the man, and also properties in the company's names that they had as well. So it's ostensibly a business empire that we are talking about in this case. Their relationship ended, and the question was whether the wife was entitled to any of these properties, and indeed, in what amount. And the judge found that there was a common intention of parties that, with the exception of 1 category of properties, 1 category of properties was outside this, but with the exception of that 1 category, all of the other properties were subject to a common intention that they would be held on behalf of both the man and the woman jointly and equally, and that the woman had relied on that common intention to her detriment. She had done all sorts of things. She'd put money in, she'd worked, and she'd undertaken a liability. And that was obviously sufficient detriment in order to support a common intention constructive trust. And this, of course, was quantified. The judge, to quantify it. And as I've already alluded to, the agreement was that they would share the properties jointly and equally. And that effectively represented an agreement not only about the fact of the beneficial share, but also the size of the beneficial share. And so the judge moved to an award of a 50-50 for predominantly most of the properties in favour of the woman. 50-50 of the man and the woman, they had to share it. Now, I said a little earlier on that I would touch on the principle in Stack, or the loose suggestion in Stack, that when you're dealing with commercial cases, you just use resulting trust. Now, the judge accepted and acknowledged that the man and the woman inevitably had put unequal amounts of work, effort, and money and finance into this portfolio. The judge didn't suggest for a moment that it was broadly equal, the contribution. He accepted that the woman had put in everything that she had, but that doesn't mean that it was actually equal in amount to what the man had. Nevertheless, notwithstanding the injunction in Stack Endowment that we use resulting trust today for commercial cases, this really predominantly is a commercial case, and Stack Endowment, the principles of common intention and constructive trust were used to divide up the property and establish shares and the like. So we've got 3 more cases to do quickly. I'm not going to spend very long on Rowland and Blades, which is the next, it's on page 18 of the printout. The reason why I'm not going to spend long on that, Jeremy's going to touch on that because it's there's a very interesting, some issues under occupational rents that come up under Rowland Blades. Very quickly, it's a joint ownership case. It's just like Stack. The man and woman were not married, and they bought a weekend home together. It's nice for some, a weekend home together. And during the conveyancing, they signed a joint ownership form saying they were going to share it as joint owners. And they eventually, the TR1 form on the conveyancing was also filled out, although it wasn't initially filled out, it was filled out with a cross saying they wanted to share as joint owners. However, the man paid the whole of the price, with the purchase price without a mortgage, and the pair of them had no joint bank account and no pooled resources. So the question is, when we stop the frame, is what happened next when, after really not a very long, within a year, they split up. And then there was the question of then how they divided the ownership of the weekend home. What happened there? Did this case fall within the Stack and Dowden application of a joint ownership in equity reflecting joint ownership in law? Or was this one of those exceptional cases where the parties' intentions must obviously have been so different because of their conduct, because of the separation of their finances, and because one side had put all the money in? Which was it to be? And the answer was, in this particular case, that the property was to be held 50-50, because the length of time involved wasn't very long. So there wasn't very much time for them to change their decisions, and the judge felt very much bound by the documents that existed at the time of the conveyance, at the time when the property was purchased. They all pointed towards joint tenancy. And so for that reason, the judge did not consider that there was any common intention of constructive trust going the other way. There was no post-acquisition agreement or any other intention other than the common intention on which he had relied. Now, the reason why this is interesting is that, therefore, I would say that's a windfall. It was a fair decision as regards the judge saw it. The judge thought the outcome would be harsh. I've done an extract on page 20 from the judgment. The judge thought that was quite a harsh, potentially a harsh result. But the judge also acknowledged that this is Stack and Dowden, and that one has to pay great attention to the presumption that's there for joint ownership. And in this particular case, not only was it there, but it was buttressed by these documents suggesting that effectively there was an express declaration of trust. And because of those documents buttressing the presumption, that the judge felt that it couldn't be departed from. And we come actually, and that's in the way of these things, one always runs out of time. One comes to, on page 21 to the case of Hudson and Hathaway, which is the probably most interesting case. Before I embark on Hudson and Hathaway, I'm just going to mention that Jeremy's going to talk about the occupation rent claim that was made in Rowland and Blades, the case I've just discussed. And what's interesting there, well, the question you might want to ask yourself is, well, given the harshness on the man in that case, do you think that the court took away with one hand and possibly gave with another in relation to occupation rent? I'll leave that to Jeremy to talk you through that. Hudson and Hathaway. This is another joint proprietor case. It's very interesting. It would be very interesting for people who are doing, I would imagine, co-ownership disputes where parties have separated and they're dealing with trying to negotiate their arrangements. And taking this quite quickly, it was joint ownership, so therefore at the time of purchase there was no doubt that was owned jointly and therefore effectively 50-50 if there was going to be a split. The parties separated, and then the parties negotiated between themselves as to how they would sort out the division of their assets. And then if you look on the sheet of 2013, there were emails which made it quite clear that the two parties had agreed that the woman would take the whole of the house and that the man would take other things. And what that effectively meant was that the two parties had a common intention which was clearly different to that at this time when they purchased the property. When they purchased the property, it was a joint tenancy in equity, joint tenancy in law. But in these emails in 2013, they were clearly saying the woman become the full beneficial owner. Question is then, what happened when the man then tried to get an order for sale and he asked for equal division of the proceeds? The lower court found that there was a clear agreement and common intention that the woman was to have the entire equity. And the judge also said that the woman had to prove detriment and that she had done so by not making any further claims against the man. And the sole ground of appeal was whether the judge had been wrong to decide that there was sufficient detriment. So in the appeal, which is on page 23 now, on the issue of detriment, we have probably the most interesting and a very surprising decision that was formed by the appeal judge. He said, on the issue of detriment, if you look at Stack and Dowden and Jones and Kilcoyne, it is quite clear that, and I'm going to read out the letters in bold on page 23. Go to page 23. Oh, I'm sorry, we are on page 23. The bold has come off. But in the paragraph which says following a survey of the authorities, if we look at the second sentence there, he said, in the domestic consumer context, an express agreement as to beneficial shares will suffice without the need to establish separately that the beneficiary had changed position in reliance on the promise. Now that's very interesting, because if two parties have separated and they're negotiating, and at any given moment in time, they both together form a common intention that one party will have a slightly different share, what this judge was saying in this case is that that common intention then represents the way in which the common intention constructed trust works at that point in time. Now, one of them may then disagree subsequently, but that won't affect the position because you just go back to the last common intention. And what the judge was saying is you don't need detrimental reliance on that. So in this particular case, the woman agreed with the man that she was going to have the whole of the property. And she was at risk that he might go back on his agreement, which he eventually did. And what the judge was saying is it doesn't matter if he goes back on the agreement, you, the woman in this case, you don't have to show that you relied on that to your detriment. Now, he also went on to find that on the facts of the case, in fact, she had suffered detriment and that she had changed her position in reliance on the agreement. But why this is so interesting is that this goes back to the point I was making about Stack and Dowden and whether there is a common intention constructed trust at the point in time when you apply the Stack presumption, or if you rebut it and you say that the intention has changed, just forgetting any detrimental reliance, the intention has changed, and in the ambulatory nature of the trust, that becomes the new way, the new status quo as to where the trust is. And in this judge, it's a Queen's Bench Division judge who heard this on appeal, and he's saying that Stack and Jones do not require a detrimental reliance in this particular type of situation. Now, this isn't every situation, it's just the situation, I think, which is a joint owner's case, where the Stack presumption properly, as it was decided in Stack, is being applied, and there's some sort of issue about rebuttal or change in the way in which the common intention has been formed. I understand that's on appeal, so we'll have to watch that space as to where that's going. Just one very quick final case. I've really strayed a lot over time, but one very final case on page 24 to have a look at. I'll just literally mention it. It's a case of Fatal and Fatal. It's a sole owner case involving two brothers, where a brother one bought property in his sole name as a home for the two brothers back in 1975. And they both moved in. So it's a joint domestic, it's a quasi-domestic situation. It's a joint names case. I beg your pardon. It's a joint party case, but it's not Stag because it's not a joint names case. It's a sole ownership case. Now the question there is, would that in that situation involve the creation of a Stag type joint tenants equity? Obviously not, because it's sole ownership. These two brothers conducted their businesses together, and they had complicated financial arrangements. And eventually, the property, after brother one moved out, the property was transferred to brother two. It was said to be not for any money or any value. It was clear that it wasn't a gift. So it was a transfer where either brother one said he mistakenly thought £400 had been paid for the flat, and the other brother claimed that in fact he had paid £400,000 for the flat. That being the half, that being in relation to what he said his share was. Now, question arose in the case as to whether there was a common intention constructive trust, and the bottom line was whether the second brother was able to establish that one, there was a common intention that he would own property, and two, whether he could establish any detriment. And the short answer was, it's really an example case, short answer was he didn't acquire any interest at any time. There was no common intention that he would. and indeed he had made no contribution of any sort at any time, and for that reason, therefore, he didn't succeed in his claim. I hope that wasn't too rushed through. I will now hand over to Jeremy for the balance of the cases.
Hi, everyone. Thanks, Desmond and Sian, and thanks to everyone for tuning in tonight. I'm going to be talking fairly briefly about a couple of topics that have arisen in some recent cases that Desmond hasn't covered. And the first one is occupation rent. Just to remind us, that's where one owner has been excluded or otherwise had their rights of occupation restricted by the person in possession, and that person seeks compensation for it. And the jurisdiction of this court, jurisdiction for the court to sort this out pre-TOLATA was simply based on general principles of equitable accounting, with the broad aim of doing justice between the parties, but now very firmly based on the statute provision, namely sections 12 to 15 of TOLATA, which I'm sure you're all familiar with. A couple of recent cases, perhaps we could just have a quick look at those, Sophie. A couple of recent cases just to talk about, look at what you need to show in terms of exclusion or restriction before you've got a claim. And those cases are Bailey and Dixon and Ali and Khatib. I'm going to take them in chronological order. Bailey and Dixon. In this case, thanks, Sophie. In this case, a couple bought a property with a mortgage. It was transferred into joint names, a residential property. They lived there together with their small child. So the purpose of the trust was obvious. The relationship broke down. The mother and the child moved out and lived elsewhere. And the father, who was actually the claimant, brought an order for sale. That was resisted. She wanted the property preserved for the child, but she also brought a claim for occupational rent. And it was pleaded that there had been a constructive ouster from the property by the father. Now, the judge of first instance decided that there wasn't any claim for occupation rent. And in doing so, he suggested that what needs to be shown by her was a situation, something analogous to a landlord, to quote him, coming in and changing the locks and chucking all your stuff onto the streets. In those circumstances, he said, you're obviously entitled to damages. Well, this is the equivalent of that, end of quote, meaning something like this is what I'm looking for. And of course, we all know that rarely happens. And it didn't happen in this case. I mean, the far more common situation is that a relationship ends and sort of one person trudges off and lives somewhere else. You know, the actions are a bit more blurred than having your stuff chucked onto the street. Anyway, on appeal, and unsurprisingly, the court held that this was a clear misdirection in law. The test had been put too high. Having to prove that you've been ousted for the property is not a condition precedent. Mr. Justice Saini drew heavily on the authority of Murphy and Gooch and noted that the task of the court is now no longer merely to do justice, but to do justice between them, having regard to the statutory considerations. And it's clear that under TOLATA, a court can order credit for an occupation rent if it was just to do so, whether or not there was any proof of ouster. He reminded himself that in the case of Murphy, the claimant had left the property on the breakdown of her relationship, and that when she left, she should be regarded in the same way as a wife leaving a joint home on the breakdown of a marriage, as constructively excluded from the property. Ms. Justice Saini made it very clear that each case would turn on its own facts. There's no rebuttable presumption that if a relationship has broken down and one person leaves, that occupation rent would be payable. And you know, one can think of plenty of situations, I suppose, where that would be applicable. You know, the parties remain on good terms, the leaving partner has got other reasons for wanting to move out, that sort of thing. The next case is a Court of Appeal case, Ali and Khatib. Maybe we could just have a quick look at that, Sophie, on the slide. A Court of Appeal decision, which covers quite a lot of the same ground, but which places, on my reading, a subtly different emphasis on the default position when it comes to the payment of occupation rent. The context was different. A property was left by a mother in her will to one of her sons and his family, and they occupied the property after the mother's death. Another son, who was living elsewhere throughout, challenged the will many years later, and that challenge was successful. The earlier will was held to be valid, and he had the beneficial interest under that will, and he brought a claim for occupation rent against his sibling, who had remained, in fact, I think had looked after their mother and remained in the house after she'd died. In fact, the main suit sorted out in that they bought him out, but that they still litigated over the occupational rent. The court found the respondents weren't at fault. The people had stayed in the house, weren't at fault over the will, and they hadn't been challenged about living in the house for many years until after the mother's death. The claim at first instance failed. In other words, no occupation rent. And on appeal, the Court of Appeal upheld that decision. The judge was exercising broad discretion, and the principles that we just touched on were restated. What's interesting about the judgment is that the Court of Appeal made clear that a co-owner in occupation was not obliged to pay occupational rent merely because he was living there and the co-owner wasn't. Something more had to be shown, and the focus was very much on the behaviour of the occupier rather than the non-occupier. Lady Justice Aspelin noting that the judge had concluded there was nothing about the conduct of the family members who remained in the home that justified an award of occupation rent, and there hadn't been any interference or strict restriction of the siblings' rights of occupation. I mean, he just never tried to live there. Lady Justice Andrews agreed something had to be shown more than merely one staying and one leaving. She gave the example of an occupier exploiting the property for their own financial gain, or precluding the owner from exercising some right of occupation that they wish to exercise. The claimant, a slightly more niche point this, but it may be wide ramifications in a bankruptcy position. The claimant had tried to argue that his position was analogous to a trustee in bankruptcy, who could not take up, I mean, by definition of their role, they couldn't take up occupation of property jointly owned by the bankrupt. And he tried to argue that the case of French and Barcham, decided in 2009, was authority for the proposition that a court would ordinarily, if not invariably, order the payment of occupation rent to a trustee in bankruptcy, and that presumption should apply in this case. The court gave that fairly short shrift. It said there was no such presumption. What the court had to do was achieve broad justice. The other interesting bit, which perhaps has wider application for us as practitioners, is that the court agreed with the court at first instance that a rise in the capital value of the property might be relevant in deciding whether or not occupation rent should be paid as part of the exercise in achieving fairness. So that might be worth remembering if you're representing somebody on the receiving end of a claim for occupational rent, and the property has risen in value significantly between, the date of exclusion and the claim. It might be a good argument to deploy, and if you're in that position, have a look at this case. Okay, the next occupation rent case is one which Desmond has briefly touched on, the case of Rowlands and Blades. This is to do with the issue of quantum of occupation rent. It's never really an easy topic, and perhaps illustrating this case, that the couple you've heard were in a relationship, they each had their own properties. What they decided in early 2009 was what they really needed, was a grade 2 listed hilltop Italianate villa with acres, not to live in, but as somewhere to sort of hang out at weekends and holidays. And we've heard Desmond's explained that Dr. Ronan provided substantial funds to buy that property, and he put it into joint legal names, a step he probably came to regret. Later on that same year, he commenced a relationship with someone else, a fact soon discovered by Miss Blades, who, to adopt the rather colourless description in the law report of their conversation, said to him that she did not want him to take his new partner to the property. So, and he didn't. I mean, he abided by that firm request. And Miss Blades did use the property during that period. the court decided that at first instance that he should be awarded an occupation rent, and it assessed that at about £60,000. It felt that he was effectively excluded from the property, and that this was for 3 days per week over a number of weekends from 2009 to 2015. That was not, in fact, challenged on how it was. The quantum of days was not challenged on appeal, but the rate was. And at first instance, the court had really quite complicated expert evidence, trying to work out what the parties could have earned from the property had it been let to third parties as a venue for occasional weekends and holidays. And this expert's report was obviously quite a technical document that spoke of annual rental values, notional daily rates to rent the property, etc. And Dr. Owens approached on the basis of a daily rate multiplied by the weekends lost. And on appeal, he tried to overturn the decision that he merely got 60,000. He wanted about 216,000 as compensation for that 6-year period when he didn't use the property. Miss Blades invited the court to decide the quantum on a less empirical basis, namely a figure that would represent a fair sum to compensate the loss of enjoyment of amenities, and pointed to some authorities. I mean, a bit like sort of general damages that we see in PI type claims or breach of contract claims, you know, where people have received modest sums for, you know, jet noise for living near to Gatwick, or a cruise holiday spoiled by engine noise, and those sorts of authorities. The judge, in allowing the appeal, His Honour Judge Jarman QC rejected both approaches. He observed that neither party saw this as some sort of letting opportunity, and that financial loss wasn't suffered by the exclusion, and that the expert valuation didn't really get at what it really was that Dr. Rowland had lost, which was the loss of, as the judge put it, a grand weekend and holiday home rather than a holiday let. And the loss wasn't financial. The approach needed to be more evaluative rather than purely arithmetical. And he in fact split the difference between the sums awarded at first instance and the sums assessed by the expert as representing the annual rent divided in two, and awarded 120,000. I agree with Desmond. There's a sort of sense of a sort of score draw here, a bit of a compensation for what was a pretty tight, pretty harsh decision at first instance on the main issue. The takeaway from this is that, you know, sometimes calculating occupation rent is unscientific. Look carefully at what's actually been lost, and a formulaic approach will only take you so far. Okay, so I'm leaving occupation rent now, and I'm going to look very briefly in the time that we've got left at two cases. Perhaps we could just have the second slide up. The first, it's a really interesting case, Ralph and Ralph. A case that it's a rectification case. It deals with what happens, in essence, where no thought is given as to the beneficial interests, but somehow a cross has been put into box 11 of the TR1, which states that the transferees are to hold the property on trust for themselves as tenants in common and equal shares. Now, those circumstances, forgive me, the sort of factual basis for the claim are fairly common. A father back in 2000 wanted to buy the house he was living in with his family. That included 4 children and his partner. His eldest child was 19 and had clearly just got a job, and that assisted the father to get a mortgage. And so the purchase was made into joint names, joint legal names. And the father paid the 10% deposit and proceeded to pay the mortgage. The title was conveyed into joint names. They only used one solicitor to do the conveyancing. And the cross in the box was actually filled by the seller, not them. But there it was on the TR1. The son, Dean Ralph, brought a claim many years later for a declaration as to the beneficial ownership of the property. He claimed half of it. Now, although he didn't plead it, the father fought the case by seeking, amongst other things, rectification of the TR1, so as to remove the offending box, the cross in the box, on the basis that there had been a common mistake. And the judge at first instance held that there had been a mistake and agreed to rectify the document by removing the cross. He further held that, absent any express declaration in the TR1 or evidence of express agreement as to beneficial interest, it was wholly improbable and unlikely that the father would have sort of given his 19-year-old half his house, to the exclusion of, his then wife and children, other children, and declared that the father held 100% of beneficial interest. The son appealed. Mr. Justice Morris, on the first appeal, upheld the decision at first instance, so refused the appeal. But the son kept going. He managed to get limited permission to appeal to the Court of Appeal, on the basis that the rectification could not be deployed where there had been no positive subjective common agreement at all about the beneficial interests. And he relied on the principles applicable to rectification of commercial contracts, set out in the recent leading case of FSHC Group Holdings versus Glas Trust Corporation, a case I'm sure you're all familiar with. It's in the report, and the principles in it are set out. Now, that stance wasn't challenged by the father. He accepted that the principles applicable to commercial contracts and rectification applied in the family context. The Court of Appeal, the Master of the Rolls, no less, Sir Geoffrey Ver, giving leading judgment, voiced doubts about that in the judgment. He wondered whether that was actually right. And he sets out a number of obvious reasons why commercial contracts and their negotiations were different from, family house purchases where a father and a son buy a house. But he took the view that because the point wasn't pleaded or run before him, he'd decide the case on the basis of the case that had been pleaded. And also, at no point, you get the impression that the Master Rolls was surprised that no point was taken by father on appeal, that because neither he nor his son had signed the TR1 and the box had been filled in by the transferors, there was no valid declaration of trust that needed to be rectified. He wondered aloud whether there might also not be an argument here, but given that no one was running it, he put the issue off to another day and another case. I suppose we have to watch this space if anyone else falls into this trap. Anyway, in the leading judgment, the Court of Appeal, the Master of the Rolls allowed the appeal. The Master of the Rolls allowed the appeal, relying on the finding at first instance that there had been no agreement at all as to beneficial interests. It had never even been discussed, and so therefore the reasoning went: rectification couldn't be applied because you could only have rectification when where there was some sort of accord or agreement to correct. Rectification was intended to correct mistakes in recording what the parties had actually agreed, and here they hadn't agreed anything, so they were stuck with the declaration. So a cautionary tale. The last case I'm going to deal with very quickly, Pickering and Hughes. It's a constructive trust proprietary estoppel claim. It actually asserts no stunning new principles in these areas, but it's just an interesting, I suppose, case illustration in the application of the well-known principles to the facts of the case, and the importance of looking carefully at the evidence of agreements and the assertions, the behaviours of parties in what must have been a very punishing legal case affecting the whole extended family. Just briefly, in the early 80s, a couple owned a number of properties. In 1984, one of their sons and his wife moved into one of the properties, which had quite a lot of land with it. It was quite it's a substantial property. And the son spent about 100,000 renovating it before they moved in. It was never conveyed to the son, and nothing was committed to writing. And there weren't even any oblique references to any agreement about it in any contemporary documentation about the beneficial ownership. In 2015, following a dispute in the family, that the mother amended her will, leaving all of her estate to her daughter, and the mother served notice on the son, John, his name, served notice on John to leave this house that he had been occupying since 1984, to terminate the license and to get him out. And she amended her will to leave, I think I've said, all of her estate to her daughter. And on the mother's death, the daughter, in conjunction with other siblings, brought a claim against under TOLATA for a declaration in the property. And John, the son in occupation of the property, fought the case, asserting he was beneficially entitled. He failed. Reading it seems harsh in a way, because he'd spent a lot of money renovating the property, 100,000 in the mid-80s, a lot of money renovating the property. But the court noted that the parents had amended their wills several times over the years. There was never any mention of any agreement or assertion or understanding about the property, which could be treated, as forming the basis of a common intention constructive trust or proprietary estoppel, which is how the son argued his case, how John argued his case. There was no corroborating documentation at all, and the claim was only asserted in 2017. So the court, noting that the property was the most valuable of all the properties owned, it was surprising there was no record of any agreement, even an informal one. The court was careful to say that the inferences to be drawn from a failure to record or assert an oral agreement obviously depend on the particular factual context. Again, I say there's no statement of general principle here, but it's significant that the court noted that apart from the fact that there was no, corroborating contemporary documentary evidence, these were business people, the parents were business people, and it was likely that they would have made some record. So that's a very quick race through of those cases. Do have a look at them more closely, interesting ones. Thanks so much for listening, and that concludes my bit of the talk. So I'm going to hand you back to Sian, I think. Thank you.
Thank you so much, Desmond and Jeremy, for that extremely interesting and helpful update. And thank you all for joining us this evening. We'll be sending out an email with Jeremy and Desmond's very helpful slides, as well as a link to the recording of the hearing to you all this week. And links to both of those will be on the website as well. And we hope you might join us again on the 16th of November, when I will be speaking with Andrew Pote about how to deal with some of the problems posed by overseas assets in financial remedy cases. So thank you all again, and have a good evening.